My name is Kenneth Pascal. I'm with the Alabama Family Rights Association. I'm sitting here with Austin Burdick, an attorney out of Bessemer, and we're going to talk. Take a few minutes to just talk about a piece of legislation that's been in before our legislators for the last several years. It's called the Children's Equal Access Act. And Austin, before we get started, could you just briefly share who you are and what practice you cover?
Yeah, I practice law in Alabama. I'm primarily family law, domestic relations, and constitutional law. Deal with some of the more complex issues, and it's allowed me to travel throughout the state to handle those kinds of issues.
Okay, that's great. And once again, thanks for taking the time to share about, which I think is one of the most critical issues within our country. You know, as I wear my hat in the military, retired, I spent 21 and a half years in the military, and I think our two things we're fighting for is our country and our kids. And so this legislation is just a means to fight for our next generation and protect our kids from being placed at risk. So I have just six key points which we'll kind of cover today. And first one is, what is the problem, the impact on kids when they lack a consistent relationship with two parents?
Well, the problem is that kids don't get to see both of their parents on a regular basis. You know, statistically, I guess. In Alabama, we're kind of all over the place as far as what judges do. There's some judges who are very motivated to try and order shared parenting, but there's a lot of judges who are kind of old school, so to speak, and they want to do things the way that they were done when we were just starting to handle divorce cases, and when we were just kind of guessing what to do. And so the problem is we're still kind of stuck doing a lot of guesswork in a lot of these courtrooms, and we haven't taken the time to pay attention and say, well, what's been the outcome of all of these things that we've been doing for the last 20, 30, 40 years? And now we've got scientific research and data, and we've got an opportunity to change things and say what gives kids the best chance at having happy and prosperous lives.
Right. And I know that you mentioned about we really haven't looked at the outcomes, and I'll tell you from our organization standpoint, from talking with, looked at the data from the United States Department of Health and Human Services, and right here in Alabama, our department, DHR, Department of Health and Human Services, it's clear the outcomes is when you deprive a child from having a relationship with both parents, those kids are placed at a higher risk. Whether we look at juvenile detentions, high school dropout, teenage suicides, all that has a negative impact. But you mentioned about there's data that says there's a better way to do it. And we do have a legislation called the Children's Equal Access Act that we have had before our legislators the last several years. And could you just briefly just summarize the bill, say what the bill does?
Okay, well, the bill does several things, all good things.
Right.
But one of the things that it does is I think the way that I like to describe it best is to kind of talk about it in terms of it standardizes outcomes in the sense that it takes the scientific data and it says, okay, in situations where you've got two fit parents, we're not talking about abusive parents or anything like that, but where you've got two fit parents, then we need to start our conversation. And so the way you do that is you put in place a rebuttable presumption. That's a legal term. It just means that you put in there that under the law it's presumed that you're going to go this direction. But if the evidence takes you in a different direction, then you go in a different direction. And the rebuttable presumption is that we're going to start our conversation with shared custody, with something in that range of a 50-50 to a 35, somewhere between 50 and 35% for kids, because the scientific research, the data that they've collected, dealing with hundreds of thousands of kids, has shown that this is what yields the best results. And what it does is it instructs judges and it allows them to keep their discretion. But it says you need to exercise your discretion within this field of play. That you need to treat fit parents like fit parents, and you need to treat unfit parents like unfit parents. And so that's probably one of the major things that it does. It also does some other things in it where it requires that the judges if they're going to go away from shared parenting, that they need to provide a reason for why they do that when they issue their order. They got to supply some facts so that the Court of Appeals and the parents and everybody who looks at that order knows why there's not shared parenting in this case, because you've got to overcome a mountain of scientific research that says this is what is going to yield the best outcome for these kids. It's going to get them through high school. They're going to graduate from high school. They're going to go to college. They're not going to run as high a risk of drugs and going to jail or juvenile detention or teen pregnancy. All of those risk factors go down dramatically if we act in this way. And so you better have a good reason. If you're not going to do this, it's got to be a really good reason. You need to back it up with some facts. The other thing that the bill does is it gives the parents the opportunity and the power to supply parenting plans to the court, to where the parents are empowered and they get to say, hey, based on the facts of our case, based on the facts of our situation, here's what works best for us and our kids, so that we can make sure that these kids have the best possible opportunities.
Right. And I think that's now you hit on three main points of the bill. One, that creates a starting point of conversation, and I noticed you did not say it mandates 50-50.
No, absolutely not.
And you're saying anywhere in the range you start there, but the scientific data gave you a buffer from 50%, 35% kids have better outcomes, and then the judge write down why, and then the parenting plans is you putting the power or keeping the power in the hands of the parents, what it should be. So I think that's great there. And how does the bill shift the role of the family law attorney? What would that look like?
Well, I think some of the things that would change for me, like if I just thought about just a standard case that comes walking through the door. First of all, it doesn't change the standard of review for like a subsequent modification. So like say somebody who got divorced, 5 years ago, and things have changed in their lives and they feel like they want to come in and change things, then all the standards that have been laid out and set forth in the law, those are not going to change. This bill doesn't really change any of that. This bill is just consistent with the statement of public policy, and it also really addresses those situations where you have initial custody determinations.
Right.
So for me, if it's an initial custody determination that comes in, say it's somebody who's filing a paternity action or a divorce or something like that, then what it does is it lets me know, first of all, right off the bat, that I'm not going to waste any time, but instead I'm going to jump right in and try and put together a parenting plan right out of the gate. I'm going to talk to my client, get them to discuss with me what their work schedule looks like, what their spouse or the mother or father of their child, or whoever the other party is, what their work schedule looks like, how old the child is, where they go to school, how far apart they live from each other, all of these factors, and try and formulate a good plan and try and do that from the very beginning. Right. And hopefully save some time. And then that gives us something to submit to the other side to see if maybe we can negotiate based on what's best for everybody. It also puts me in a situation where I know when I'm talking to the other attorney, dealing with the other side, that we're going to start our conversation even before we go to court and have a conversation with a judge, that we're going to start talking about shared custody and how to make that work. Right. And the alternative is to say, well, if that's not what you want, then you tell me why you think that won't work. Instead of starting our conversation saying, well, let's pick which one of these parents gets to be a parent and which one gets to be a visitor. Right. That is so nice. That would be ideal. That would be a dream to be able to start conversations with, instead of which parent is this child going to lose, but instead start the conversation, how do we make sure that this child keeps both parents as much as possible?
Right. And I think that's pretty awesome. Now, what are some of the things that the people who oppose this legislation? What are some of the things they're saying?
Well, some of the things I've heard are, it takes away the discretion of the judge. And I kind of addressed that earlier because it doesn't really do that. It doesn't take away discretion of the judge. What it does is it does kind of rein in the outside edges, though. When we deal with a criminal case, we have sentencing guidelines. If you commit jaywalking, then judges can't put you in jail for life or give you the death penalty for jaywalking,
Right.
because it's outside the limits. It's just because, regardless of what the facts might be about that case, the severeness and the seriousness of that crime could never result in a death penalty. And the same thing, if somebody's been accused of murder and they're convicted of murder, we don't give them a $50 fine either. And so what this legislation does is it says, okay, when we've got two fit parents, then we treat both of them like fit parents. And when we've got a parent who's not fit, then we're going to use the laws on the books the way that they're written. Code of Alabama 30-3-133 basically says that there's a presumption that if somebody's abusive, then they're not going to get custody. And so what this does is it tells the judges, hey, you're not going to take this mom or this dad who's abusive and treat them like they're not. Just pretend it didn't happen. And at the same time, you're not going to take this parent who's not abusive and give them supervised visits and drastically reduce the amount of time they get to spend with their child. Because we know the outcomes are going to be bad if we do that. It helps, I think, change the mindset of a judge from asking the question of what's going to be convenient for people in this case, instead says what's going to be the best course of action to yield the best outcome for this child.
Right. Okay, that's great. Now, did I hear you correctly? You were saying that there's already in the Alabama code that there's a rebuttable presumption if there's domestic violence or family abuse, that it creates a rebuttable presumption throughout the entire state for every judge to assume it's not best for the child to reside with their parents. Is that correct?
Yeah, that's absolutely correct. That's already in the code. This law supports that. It doesn't change it or alter it. It doesn't diminish it. In fact, it's 100% supportive of it.
Right. Okay, that's great. So basically, what this bill does, it creates a rebuttable presumption that shared parent is best. And then also, if there is abuse or family domestic violence, it's a rebuttable presumption already that it's not best for the child to reside with that parent.
Absolutely.
So this truly is about two fit parents then.
Absolutely.
Trying to maximize the child best outcomes. So that's great. How have we since addressed the opposition concerns? And I think we already just identified that there's concerns dealing with domestic violence, but the code is clear in that area. So we'll close with this last question. What would outcomes for kids look like if this bill passed?
What would the outcomes look like? The outcomes would look like children who grow up and who are better able to sustain meaningful and lasting relationships in their lives. Not just with their parents, but with their peers and their spouses when they get older. It would look like children who are far less likely to go to prison, to go to jail, far less likely to view suicide as a way out of their problems. Children who are far less likely to use drugs, far less likely to be pregnant as a teenager, far less likely, and when I say far less likely, I'm saying 3 or 4 times. When you take a child and remove one parent, it becomes 3 or 4 times more likely that this child will have these problems. And so this legislation says, I'm not going to do things that are going to make it 3 or 4 times more likely that this child will be unsuccessful in life and unhappy.
Wow, that's a pretty big percentage.
That is huge.
Yeah.
It's huge, yeah.
And well, I tell you what, I definitely appreciate you taking the time to share with our people out there, our lawmakers, the general public about the Children's Legal Access Act. If people would like to know more information about this piece of legislation, there you can contact the Alabama Family Rights Association at ALFRA.org. And And also, if you'd like to know more information about the bill, this legislation, contact Attorney Austin Burdick. And how can people contact you?
Well, a lot of people contact me through my website, austinburdick.com. They can also call me if they want to call the office, 205-565-8909. And I'd be happy to try and help you, answer whatever questions you might have, see what we can do to get things turned around to where we get more situations where more kids are in better situations.